Go on and on. Sorry. You got it or you don't.
All right. Let's see. Rollins is Clark. Mr. Reed is on wall. Okay, I got it. Chester, Brittany Ross. Chester. Chavez is on Jackson. Nelson, who's Nelson on? Attorney. Yeah. Okay, go ahead, I'm sorry.
I'm on Morissette.
All right, got you, thank you. But I think I have, everybody.
Good morning, and Mrs. Ross is in the office with me, and Attorney Reed should be logging on from another device right now.
Did he name his device?
That is, I think it's iPhone 2 or 12 or something. I will rename that when we come back to the office.
It doesn't say that, but I need him to name his device because I just can't let anybody in.
Okay, hold on.
And I don't know who he is if he don't name his device. All right, I only need who's on Tinsley. The only attorney I'm missing.
She might.
Okay, so I'm ready, I can start off.
36th District Court, City of Detroit, State of Michigan, non-session with the Honorable Judge Ronald Giles presiding.
Oh, I'm not Cody Black. There's Cody Black. Might be him. That might be his. All right. Mr. Bradford? Yeah, that's gotta be it. Okay, I'm just gonna start calling. Calling case number 21-55756, the people of the state of Michigan versus Elton Chester. Defendant is charged with count 1, count 2, count 3, gambling activities, felony violations, count 4, count 5, conspiracy gambling, count 6, criminal enterprises. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Robert Hayes, Assistant Attorney General, here for the people, P69006.
Hey, good morning, Judge. Respectfully, Jihad P82492, appearing on behalf of Mr. Elton Chester for today's probable cause conference.
Mr. Chester on?
I believe so. He logged in a while ago. Maybe he didn't name his device, but he's definitely logged in.
Yeah, he probably didn't name it.
Well, if he didn't name it, we don't let him in.
I understand, Your Honor.
Waive this appearance
Yes,
for the
because-
purpose. Okay.
Yes, Judge.
Send this matter for exam.
Yes, Your Honor.
The party's available Tuesday, May 23rd at 10 o'clock.
Momentarily, Judge.
Your Honor, I'm sorry. I'm up in Petoskey that day.
Wednesday, May 24th.
If you have something later, I have a sentencing in Macomb County, but at 9, but I can be there after that for sure. Otherwise, I'm open
Is it-
all day on the 25th.
11 o'clock?
25th,
No, 24th at 11.
24th at 11, Your Honor.
That works?
That works.
Yes, Your Honor.
All right.
Mr. Kadaf, could you put the your email in the chat so I can get you discovery?
The chat function is not open for everybody to look at, Mr. Hayes, but I can send you an email.
That'd be great.
I'll get you on the state bar. Actually, I have you. We've worked together. Thank you.
Yeah, thanks.
Thank you, Judge.
Thank you.
So I guess we're not ready. I'm Brittany Ross. Mr. Reed is not on here. Parties ready on Cortez Jackson.
Ready.
Calling case number 216143. Oh, hold on. He's on. See how it's a delay before they get it? Okay, there it is. Calling case number 216143, the people of the state of Michigan versus Cortez Jackson. Defendant is charged with count 1, malicious destruction of personal property, $1,000 or more, but less than $20,000. This matter is scheduled for a probable cause.
Good morning, Your Honor. For the people, Philip Henderson, P86029.
Good morning, Judge, to you and your staff. May I please this honorable court, Justina Shabazz Davenport, P number 82743, appearing on behalf of Mr. Cortez Jackson, who is also present by way of Zoom.
So Jackson, can you state your name for the record, please? Mr. Jackson, can you hear us?
Judge, it does not look as though he's connected to audio. However, I am in contact with Mr. Jackson, and I see that he is logged onto Zoom. However, his audio does not seem to be working. I would ask the court to waive his presence for this proceeding, and I will update him on anything he cannot hear.
All right, the court will do so. I'll set this matter for exam. Are you available May 23rd, 23 at 10 o'clock?
Yes, Judge, I actually am.
All right.
And Judge, I do want to just place it on the record. I see that I received 2 emails from the people, what appears to be discovery, paper discovery, as well as possibly video discovery. I'm not quite sure. I received one on yesterday and one, it looks like this morning. I was unable to open both of them with the short amount of time. I know that there's an expectation for us to redact discovery before presenting it to our clients, and the people no longer redact it now. So I don't know what's in there, but what I have done is I have a discovery order that I would ask the court to sign. Is asking for all digital discovery, including 911 calls, body worn cameras, etc. Standard discovery, and I will ask the court to sign it when I email it over.
All right. Problem? But if for some reason you can't open what you do have, you need to contact the prosecutor's office again.
I sure will.
Okay, all right.
Thank you, Judge. You all take care.
Thank you, you too. Take care.
Take care.
Good morning, Madam Clerk.
Good morning, Ms. Jennings. I have you checked in already. I'm getting ready to call your case right now.
Okay, you know what? Can you do? You know what? I was in another something else. Can you put my title back on? I don't know how to put it back on.
Put your what back up?
It's attorney. It was. I had to take it off for something else on purpose. Now I tried to put it back on, but I don't know how to put it back on there on my in front of my name, please.
Oh, you just want to put attorney in front of your name?
Yes, thank you. I had to take it off for something else. Thank you.
Okay, you're welcome.
Thank you. My client is in the waiting room.
Yeah, well, they didn't name the device, so I can't let them in if they don't name their device.
Well,
They
I
have to
told
put their device.
him I said, listen, you gotta put your name on your device, period. So let me just send him another text, tell him, put your name on your device. Thank you. Good morning, Your Honor.
Good morning.
I did send a message to all the people in the waiting room.
Thank you.
And Mr. Reed is in the office now, so we're ready whenever the court is.
So do you want me to wait on him, Ms. Jennings, or?
I'm texting him right now because when I talked to him 15 minutes ago, he said my name is on there. I'm just, I don't know. You can go ahead, you can come back to us in a minute because I'm trying to tell him that they say that his name is not on his device. So
he has to name his device.
right, yes.
Yeah.
I don't know.
Yeah, I can't let them in without their name device.
Okay, thank you.
Their name has to be on there so I know who it is.
Yes, thank you. Yeah, I just sent him another text and said, you have to do this correctly. So.
I'm gonna call another case, Ms. Jennings, while we're waiting, okay?
Okay, fine, thank you.
Calling, party's ready on Brittany Ross.
Ready, Your Honor.
Calling case number 2356832, the people of the state of Michigan versus Brittany Ross. Defendant is charged with count 1, malicious destruction of personal property, $1,000 or more, but less than $20,000. Count 2, assault with a dangerous weapon, felonious assault. Count 3, failure to stop after a collision. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. For the people, Philip Henderson, P86029.
Good morning, Your Honor. May it please the court, Daniel Reed, P number 30965, appearing on behalf of Ms. Ross. We do consensus matter proceeding by Zoom. Ms. Ross, would you identify yourself for the record, please?
Yes, I'm Brittany Ross.
Keep your voice up.
I'm Brittany Ross.
Thank you. We are scheduling this matter for a preliminary exam, Your Honor.
Available Tuesday, May 23rd at 10:30.
Yes.
Okay, anything else?
No, that'll be all. Good to see you, Your Honor.
Good to see you too, then.
Thank you. Everybody stay safe.
You too. Take
You
care.
too.
All right.
Okay, Madam Clerk, he's corrected it. He's in there in the waiting room. Thank you for your patience.
He must be in another waiting room. Cause I don't have no one that says William Morset on here.
No, it's Kivante Foley. My client is.
Oh, I from Morset.
No,
Oh,
my
I'm
client.
sorry.
That's okay. No problem.
So Ms. Nelson's phone.
All right, I got him. All right, I got him.
Thank you.
Calling case number 2356245, the people of the state of Michigan versus Cavante Foley. Defendant is charged with count 1, failure to stop at a scene of an accident resulting in serious impairment or death. This matter is scheduled for a probable cause conference.
For the Philip Henderson for the people, P86029.
Yes, good morning, Your Honor and staff. Madeline Jennings, P 44692. Appearing on behalf of Devontae Foley, who is on Zoom and has no objection to Zoom. And this is a waiver.
Oh, Mr. Foley, can you state your name for the record, please?
Yes, Kevontae Javon Foley.
All right, people have any objection?
No, Your Honor.
All right, Mr. Foley, you understand that you have a statutory right to a preliminary exam where the state must show by probable cause a crime was committed and probable cause you had something to do with committing that crime. You understand that, sir?
Yes,
Has anybody promised you anything or threatened you in any way to get you to waive your right to preliminary exam?
no,
You're waiving your right freely and voluntarily after having opportunity to talk to your attorney about it.
yes,
Do you have any objection to the court signing your name to the waiver form and initialing off?
no,
And Attorney Jennings, do you have any objection to the court signing your name to the waiver form and initialing off?
Oh, Your Honor.
All right, court will find you freely and voluntarily waive your right to preliminary exam matters filed over the Wayne County Circuit Court Criminal Division for arraignment on information, which will be June 1st at 9 o'clock. And bonds continue.
Thank you, Your Honor. Thank you, Madam Clerk. Okay, we can sign. He can go now, Your Honor.
Yes, yep.
Okay.
We
I'm
go.
gonna call you Mr. Foley. Thank you.
okay, thank you.
Madam Clerk, Mr. William Morissette is in the waiting room as iPhone, and he's unable to change the name.
It looked like whoever was on the iPhone just logged off.
Okay.
Are you ready?
Yes.
Calling case number 2356784, the people of the state of Michigan versus William Morissette. Defendant is charged with count 1, police officer assaulting, resisting, obstructing. This matter is scheduled for a probable cause conference.
For the people, Philip Henderson, P86029.
On behalf of Mr. Morissette, this is Sophia Nelson of Neighborhood Defender Service, P77960. Mr. Morissette is not present, but I have been in communication with him. I mean, he is attempting to be present, but.
You want to waive his appearance for the purpose of this hearing?
I will, Your Honor.
All right. So we'll do so. Asking for an in-person preliminary exam.
I am, Your Honor, but I am out on vacation the week of the 22nd next week.
What we got on the 30th?
30.
He says he's logged back in if he could be admitted as iPhone.
Nothing.
No. We can't identify them, we don't admit them. Nothing?
No, nothing.
All right, May 30th at 9 o'clock.
I'm house counsel that day at Frank Murphy. And I also have 4 probable cause conferences at 8:30. I could get something in later that day.
Well, I don't know what later that day means. What does later that day mean?
I could do 1:30.
Nope, nope. No. It's not gonna work.
I'm house counsel for the 8th floor, so I have to handle all the probation violations that morning, and
What are we on 31st?
We have 11 o'clock.
9 o'clock on the 31st.
Your Honor, I have
I'm
an
not gonna
8th.
keep you dates on it, man. When you take a case, you take the date that the case comes with. Now, you're on vacation that week, and now I gave you 3 dates. How many dates am I supposed to give you?
Okay, I have.
You're gonna have to work out. That's the only thing I can tell you.
Okay, then I will take the date on the 30th instead, Your Honor.
All right. You said we don't have anything else, but you want late morning? I can give you late morning if you want that.
That would be ideal, yes, thank you.
Right. Do May 30th at 11:15.
Thank you, Your Honor.
All right, thank you. The fine has been continued.
Parties ready on Ramon Tinsley?
Yes, I'm ready.
Calling case number 23-56828, the people of the state of Michigan versus Ramon Tinsley. Defendant is charged with count 1, weapons carrying concealed, count 2, police officer assaulting, resisting, obstructing, count 3, weapons felony firearm. This matter is scheduled for a probable cause conference.
Philip Henderson on behalf of the people, P86029.
Good morning, Judge, you and your staff. Cody Bradford with Neighborhood Defender Service, P85944, on behalf of Mr. Tinsley, who is present and consents to Zoom today.
Mr. Tinsley, can you state your name for the record, please?
Ramon Tinsley.
Thank you, sir. Counsel.
Judge, I do have paper discovery. I just got an email about 2 minutes ago that digital discovery has been sent. I have not been able to look at it yet. We would like to set this for an in-person exam, and if there's any issue with missing discovery, I will reach out to the prosecutor in between now and then.
All right, well, just in case, I would also suggest you get a written order from the court. I can act on those orders.
Yes, Judge, will do.
All right, available Wednesday, May 22nd at 9 o'clock. I'm sorry, Wednesday, May 24th.
At 9, yes, that should work for me.
All right, anything else?
Nothing else from defense, Judge. Thank you.
All right, thank you. That concludes the hearing. You can sign out.
Have a good day.
Mr. Chen. Thank you, too.
Mhm. Mr. Tinsley, you can sign out. You're
Okay,
all set.
Okay, thank you.
You got your date, right?
What was it, May 24th?
May 24th at 9 o'clock.
Right. I have a question. Do I talk to my attorney?
I'll try.
Excuse me?
Go ahead.
Yeah,
Go ahead.
Is it any possible if somebody from the judge or somebody can email my employer about what's going on? Because they was thinking I was going to jail and I'm currently unemployed and they needed somebody further than me to explain to them what's going on so I can get back being employed. I'm currently unemployed right now and I need to get back to working.
Okay, we can give you a letter when you come into court, that kind of thing, but you probably need to have your attorney write something to say that you're going through a case and you're not incarcerated. And looking at these
Carrying concealed weapon.
and I got that. I got carrying concealed weapons, and it says pure assault, and it says weapons. I don't know if it's weapons. It's probably firearm.
It's a possession of a weapon during the commission of a felony.
He wasn't.
So what paper was it?
Fleeing and resisting.
I'll give him a break.
Yeah, get your attorney to write a letter, but the chances of you actually having to be incarcerated are slim to none.
Right. That's what I wanted them to understand. So I talked to my attorney about this.
Yeah.
Okay, thank you.
It's not Wayne State.
Pardon?
It's not Wayne State Police.
I'm not sure. That's the words that we come in and argue on. So sometimes that hamstrings us.
Yeah, no, I understand.
Come on.
I wonder who they got over there drafting the warrant.
All right, so that's all the PCCs. Just got this. That's exam. That's for council.
We don't have,
Oh, here it
attorney.
is. This was in the file.
Oh,
Huh?
we don't have the attorney or the,
Defendant?
right now.
Elijah was on, he was,
Mr. Elijah,
yeah, he was on the,
chief,
I thought it was Pete.
Elijah,
Oh, I'm getting them mixed up. That's a she?
yeah,
Is her first name Emily?
Emily Elijah, right.
The prosecutor and the defense attorney are both here for the nine o'clock.
She's here.
Oh, can't use them.
The defendant is stuck in traffic. His attorney said he'll be here at 9:20, and the witness is on the way also, according to the prosecutor.
Well, I'm waiting that long for him. Let him know.
That case is DPD, Your Honor.
What was that came out?
This will be for that next case.
Thank you.
So, did I did it right.
San Antonio. Didn't make 10, 20 years, so he gets, so it's like, he and everybody thinking that, oh, it's a ball, it's a hard deal. Pretty set up.
When is the actual,
September, June. So we get fifth grade, we got jail license last year.
Oh, you say you wanna see Monday's document. What's Monday, 22nd?
Then you hate that you're not up there. Then you hate that you're not.
Now, remember, this is that chop shop from, yesterday.
Yeah.
So Judge, if
Oh, this
he,
held in park, right?
yeah, if, Mark Brown brings his client in tomorrow morning and you arraign him on the cases, would you set it for the same day? Oh,
Yeah, so we do it,
yeah, it makes sense.
So, all right. I don't think they're gonna be able to show what they need to show.
Oh,
I'll bring them in for the next same date. That way, if I can dismiss it, if it's dismissed. But I don't know, I can't, although Mark Brown was sitting there. he wasn't
Right.
Part of the exam.
right.
He was trying hard to get something.
Huh?
Yeah, he was trying hard.
prosecutor.
The prosecutor was trying hard.
I
Well,
know.
what if they did this, he was trying to get all these, I was like, really, dude, come on, you just like, And Chris is so cool, it's like.
Yeah, Chris is
I
back
just wait to see
there.
what the judge goes, I know.
And then he'll get a,
They don't know when they get these prosecutors, man, they just.
Actually, that prosecutor's been a prosecutor for.
I
a
know, but
long
the thing
time.
is.
Oh,
he should-
really?
So he
Yeah.
should
He's
know
like
that
brand
you
new.
have to have certain things in place. That's what gets me, I know he's been around.
I don't think
he asked for
I don't
it.
think he's used to doing exams. I don't know what it is.
Oh, maybe that's
Sometimes
it.
when you switch up, you know,
I know he's been around, I've seen him.
it's been around a long time.
He sure was asking me and Darren for advice when we walked.
Yeah. What do you think about this?
Oh, really? Oh, my goodness.
He was incognito, he didn't know exactly, and one of the guys said, yeah, man, I said, oh, wow. So I said, yes, you guys, yeah, man, what do you think? He said, I know you are some more, you got the insights, man.
And Judge, you say you won't be here on Friday, right, next week?
Yeah, 26.
Oh, what's that? What's that? Okay. You all right?
Huh?
You okay?
Him taking it off for her birthday.
Yeah, sure.
So the 25th, the 26th is Friday.
Yeah.
So your schedule, so you still got some stuff on you still got some room on the 24th?
I got all day on 24, all day on 25th.
We set up pretty good.
Yeah, we're good. 25th. No, I got a couple days on the 25th. I'm not scheduling anything for the 26th.
You gonna put some PCCs on there, huh?
You can't put a PCC.
So I'll get someone to cover the PCC.
Right, right.
Shoot, I'm curious to see how the docket looks next week. So these people wanting to come clicking in.
I think we're prepared to proceed.
Would you stand up, please, sir? Stand up here.
Calling case number 2356514, the people of the state of Michigan versus Morris Broadix. Defendant is charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3, weapons, firearms discharged from a vehicle. Count 4, weapons, firearms possession by a felon. Count 6, weapons, dangerous weapon carrying with unlawful intent. Count 7, count 8, count 9. Count 10, count 11, weapons, felony, firearm, habitual offender, for to notice. This matter is scheduled for examination.
Good morning, Rhonda Hadar for the people, P84161.
And good morning, Emily Elijah, P85039, on behalf of Mr. Broadnax. Mr. Broadnax, please introduce yourself to the judge.
Board Judge Broadnax, Judge.
Broadnax, your people's at 9 o'clock.
Yes, sir, Judge. I actually got to get a ride to drop my kids off. I know it's not no excuse. I know you want to hear it.
I don't care. I don't want to, you're right. I don't want to hear.
I'm sorry, Judge. It won't happen again.
I hope not. I normally don't wait at all.
Yes,
It's
sir.
only a half hour.
Yes, sir.
You know, I just take the issue.
No, sir. Yes, sir.
And I don't do sweats in my courtroom.
Yes,
I do
sir.
T-shirts. You dress for my court.
Yes, sir.
You want me to respect you, right?
Yes, sir.
I want the same thing. I want the respect. Okay, that's why you dress for court. Shirts and collar, please. Next time you come to court. All right?
Yes, sir.
Thank you. If you have to come to court. All right, ready to proceed?
Have a seat.
Yes, Judge. Before we call witnesses, I believe defense counsel is going to stipulate to People's Exhibit 1, which is a certified copy of a register of actions for purposes of felon possession that shows that the defendant, Morris Broadnax, was convicted on December 6th of 2005 of controlled substances, possession, narcotic or cocaine, less than 25 grams, making him ineligible to possess a firearm at the time that the people alleged he possessed a firearm in this case. That's correct.
All right, in 2 minutes.
And then the next two, so People's Exhibit 2, I believe, People's Exhibit 2 and 3, actually, I believe, we have a stipulation as to the admission of these. People's Exhibit 2 is lab report from Michigan State Police. The number on it is MD23-603. This lab report reports that the firearm collected from the possession of the defendant, Morris Broadnax, was tested by the Michigan State Police and does in fact match the casings at the scene of the shooting that is alleged to have happened in this particular case on February 6th of 2023.
I assume the stipulation is that the lab report says that the casings match a firearm that was produced to them. Now, who produced it and where it came from, that's gonna come from here. It don't come from that report.
Okay, Judge, yes, that the officer.
I just wanna make sure we understand what, I'm not gonna accept it if you're saying it's coming from this defendant. But no, then that's all hearsay. You know, I'll accept the lab report that what was done in terms of they tested the casing with the weapon and found that they matched. That the casings came from the weapon. That's what I'll take it for.
Yes, Judge, the officer in charge was testified to the recovery. I understand, yes.
Right?
Yes, I absolutely agree with you. I agree it's admissible under 76611B. That's that's the end of my stipulation.
Right, now, I understand, but I'm not sure what I haven't seen it. I'm not sure what the report says and whether the names are on the report or any other information on the report. I'll take the report for the testing because that's the primary purpose of what it is.
Yes, Judge, I agree. I went ahead too far. Next, as to People's Exhibit 3 is a lab report from the Michigan State Police. The lab number is MD 23-604. And this lab report reports that the firearm that was recovered in this case that was tested and examined in People's Exhibit 2 that was confirmed to have been the firearm that was used, that was discharged at the scene of the incident. The firearm, the DNA on the firearm is not the defendant Morris Broadnax's DNA. So just admitting both those lab reports. If the court would like a copy, I can present.
Yeah, I want to see them. Is that correct?
That's correct, Your Honor, under 76611B. Judge, if I can clarify, in People's Exhibit 2, the relevant firearm, there were 3 firearms tested. The relevant one is item 4 on page 3. And then as it relates to People's Exhibit 2, item 1.
Maybe back house.
What, yeah, sure. Unless you want to keep them, you can. Like,
Well, you might need them for questions.
I think those were all the stipulations that we had at this point. I guess one thing I will do is I'll move to admit People's proposed Exhibit 11, which is the raw call detail records for phone number 313-742-0617 and the T-Mobile certification under MRE 8036 as People's Exhibit 11, which the Defense Counsel has had an opportunity to review.
You skipping to that?
Well, I agree when she calls that witness, that this is a
Yeah,
certification
that's
of
a
business
little early,
records.
counsel. There has to be some foundation
Oh,
put
okay.
in. Otherwise, yeah, no.
I'm not admitting them through a witness, they're a business record. So they're raw records with a certification that would come in under.
But there still has to be some foundation laid in terms of, deals with a certain telephone number, correct?
Yes, Judge,
And
okay,
you're
that's fine.
relating, and you're attempting at this point to relate that telephone number to the defendant, is that correct?
Yeah, yes, Judge, I
Okay,
will.
well, then there has to be some foundation laid.
Okay, understood, will do, after the officer in charge testifies. So at this point, I believe we're ready to call, witnesses, if the court is okay with that.
Yeah.
We will call, Cedric Bucks. Judge, I am gonna ask to share my screen at some point during this witness testimony.
All right.
Cedric Russell. CEDRIC.
Over this way, please. Over this way, please.
Go back to there, sir.
Right there, wait. Hannah. You swear our affirm to truth, whole truth, and nothing but the truth, so help you God.
Yes.
Right, pull the door towards you. Mr. Russ, you're gonna be asked a series of questions. First by the prosecutor, then the defense attorney will probably ask you some questions. And I may or may not ask you questions, all right?
Okay.
You have to answer the questions out loud verbally using words. Just may shake your head or say, say yes, no, whatever the answer is. Okay? Also, when you're asked a question, I need you to listen to that question. Answer that question, stop. Okay, so if it's a yes or no type question, just say yes or no. They need additional information from you, then they'll just ask you another question. All right?
Okay.
We all have a tendency when we are, when we're talking about something that may have been traumatic to us, we have a tendency to ramble, because we want to get it all out. You know, we'll say this happened, this happened, this happened, this happened, we'll go on like that. If we do that, I'm gonna miss something.
Okay.
If I miss something, I might not make the right decision. All right? I know nothing about this case. The thing I know about this case is his name and what he's charged with. I know your name. I get all my information from what happens in court. Okay? That's why we proceed one question, one answer at a time. That way I can understand. Okay? All right, thank you.
Thank you, Judge. Morning, Mr. Russ, will you please state your name for the record?
Cedric Russ.
Okay, and Mr. Russ, were you driving in the area of Harper and Dickinson on February 6th of this year?
Yes.
And what kind of car were you driving?
2007 Cadillac Escalade.
What color was it?
It's cream. Well, pearl white.
Okay, and around what time of day were you driving that vehicle in the area of Harper?
Between 11:30 to 35, voice like that.
Say that one more time, a little
Between
slower.
11:35 and 11:40.
Okay, was that in the morning or in the afternoon? I mean, I'm sorry, the morning or the night?
Evening.
Evening.
Yes.
And is Harper and Dickinson in the city of Detroit, County of Wayne?
Yes.
Judge, can I be allowed in the meeting room?
In the meeting room?
On Zoom?
What do you mean?
I would like to,
You're in the waiting room?
yeah, I'm in the waiting room.
Under.
Oh,
Under APA Rounded.
Did you get this?
hmm? Oh. Got it.
Yeah.
Judge, may I have permission to share my screen?
Sure.
Mr. Russ, if you look up on screen, do you recognize what's depicted here?
Yes,
Okay, what is that?
that's the corner of Harper and Dickerson.
Okay, and have you seen this before?
Yes.
Okay, is that a video?
Oh, the video here? Yeah, I mean, yeah, I don't recognize the area
Okay.
Well, no, you recognize the area, or do you recognize this video in particular?
Oh.
You've seen this video before?
Well, no, this is the first time I've seen it, yes.
This is the first time?
Yeah, well, the second
Okay.
time.
Second time.
No, she showed me, I saw the video prior to so many years.
So right outside the court?
Yes, right outside the court, yes. Today is the first time I've seen the video.
Okay. So fair to say you've seen this video before?
Outside, yes.
Okay. For the record, the entirety of the video is 1 minute and 29 seconds. I'm gonna fast forward here to about 24 seconds. Mr.
Well, wait a minute. The video has to be authenticated, so it came from someplace. He can't authenticate it. He could say he's seen the video before, which he has, which was right before he came into court, but he can't authenticate it. He can't say where it came from, you know, how it was done, what date it's from, etc. He just knows that he saw this video right before he came to court.
He's in
So
the video.
the video has to be authenticated before you show it to him.
Judge, it's my understanding that I could authenticate through and see somebody that's.
I just said you could. I'm making a ruling on that.
Okay.
No, he
Understood.
saw this 2 seconds ago, or 2 minutes ago, right before he came to court. He can't say where that video was taken from. From where? He can't say how it got in your possession. He can't say anything about it. He could just say, I've seen this video.
Okay, Judge. I will have to go about it a different way. I guess I'm gonna ask at this point if I can recall Mr. Russ after I put my officer in charge on. Okay, I don't have any more questions at this point for Mr. Russ.
Well, let me make sure. Maya, do you have any objections to that?
No, we're gonna call him.
I'm sorry.
I'll just
I can't.
reserve my cross for when you call it.
Okay, all right. Mr. Russ, I need you to step down. You go back to the witness area. We need to hear from another witness first in order to get your testimony in. Okay? All right. Thank you, sir.
People call officer in charge, Benjamin.
Benjamin what?
Wisniewski, it's Wischnewski.
I got it.
Information.
Okay, thank you.
Right? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you can come up here, please. Dark now. 22, have a seat.
Thank you, Judge. Good morning, Officer Wischnewski. Will you please state your name for the record?
Officer Benjamin Wisniewski.
And are you employed?
Yes.
How are you employed?
Detroit Police Department.
And in what capacity are you employed with the Detroit Police Department?
9th Precinct Detective Unit.
Okay, and what are your duties?
To investigate crimes.
And what is your relationship to the instant case?
In this case, I was the officer in charge.
Okay. Are you still currently the officer in charge of this case?
Yes, I am.
Okay. And as of January 23rd of this year, were you investigating a shooting involving a Dejan Boyer? Objection, relevance? Judge, the relevance of it is that the incident as on February 6th is related to the January 23rd shooting. I believe the testimony will show that the two incidents are related to each other and that one led the officer investigation of one led him to investigating the other.
And it may be related, that don't make it relevant to the charges that this man is facing. I just need to know what he did in relationship to this case. I don't care what he did in relationship to any other case. It doesn't matter.
Okay, Judge. Were you in this particular case, did you investigate a case, a shooting that happened on February 6th of this year?
Yes, I did.
Okay, and where did that shooting happen?
It happened at the intersection.
Objection, lack of personal knowledge. He can testify to it as the officer in charge of the case.
Nope.
Okay, okay.
Not if he didn't see it.
Okay, all right. Did you recover any video relating to the February 6th shooting?
Yes, I did.
What kind of video was, where did you recover it from?
I recovered it from a program called Security Desk, a program that's given access to all investigators that allows me to view any green light footage in the city of Detroit.
Okay, and what type of video was it that you recovered?
I recovered video of a shooting that happened on Harbor and Dickerson.
Okay, and did you ever come to identify the victim in that shooting?
Yes, I did.
Okay, who was that person?
That would be Cedric Russ.
Okay. And can you yourself recover this video?
Yes, I did.
If I'm asking, I'm gonna share my screen again if I still have permission.
Yes.
Okay, I have, up on screen, people's proposed exhibit 4. Have you seen this before?
Yes, I have.
What is that?
That is a Cadillac Escalade driven by Cedric Russ.
Okay, is there a video on screen? Objection to driven by.
Yeah, I'm at the.
That's okay.
I'll
I don't
strike
like.
the last part.
Understood, Judge.
I just need the video authenticator.
Yes, Judge.
Sorry.
Okay. Is there a video depicted on screen?
Yes.
Did you pull that video?
Yes, I did.
Okay. And is this the same video you pulled in this case?
Yes, it is.
Has it been altered in any way?
No, it has not.
Okay. Move to admit people's proposed exhibit 4 as people's exhibit 4, the green light video the officer pulled in this case.
Got an objection or any with you?
I'll just blood you briefly. Sir, do you maintain the green light videos yourself?
I have a copy on a hard drive.
Okay, but do you maintain those records for the accuracy of date and time and location?
I don't understand the question.
Okay, so when looking at this video, do you maintain the green light footage records yourself?
I maintain a digital copy of the video.
I'm talking about the green light system.
Are you talking about the server?
Yes.
Okay, no.
Okay. And so did you maintain these records from the server itself for the accuracy of date and time?
I maintain a digital copy that I extracted from a program called Security Desk.
Okay. And that's the completion of what you did?
Correct.
I mean, just a couple questions. So you downloaded it, correct? Okay. And the date on the video, I don't know if you can see it up in the corner. February 6th, 2023, I think it's at 11:41.
Correct.
Okay, would that date and time be accurate?
Yes.
Your knowledge information would.
Yes, it would be.
Any questions based on my question?
Yes, Judge, to your knowledge, is the green light system ahead or behind any?
It is accurate within a minute.
Okay, thank you. Move to admit people's proposed exhibit, or is people's exhibit for the video that the officer in charge of pulled in this particular case?
Exhibit 4?
Yes.
Any objection?
I agree that they've laid a foundation for it. I think it's a conditional relevancy, so I think it's, they'll be able to lay that relevancy. But at this point, I don't think the relevancy of the video has been established.
I'm sorry.
I'm
Your
sorry.
voice.
I don't get that till the video is shown. How would I know if the video is relevant until I see it? You know, the issue at this point is whether or not you're objecting to the admission of the video. To admit it, all she has to do is lay the foundation for it. Now, once we see it, then the court will make a determination on whether, you know, what weight to give it, you know, whether it's relevant, et cetera.
Understood, Your Honor. Well, I agree the foundation is good.
All right, then be admitted.
Permission to publish?
Yes, ma'am.
For the record, the video is 1 minute and 29 seconds. I'm starting it at around 24 seconds. For the record, I'm stopping the video at 1 minute and 5 seconds. Were you ever able to identify the vehicles in the video?
Yes.
Okay. Did you ever come to learn who owned either of the vehicles?
I came to learn who operated those vehicles.
Okay.
Objection. I think there's no foundation for that statement, lack of personal knowledge, you know, that's a conclusion. It's not testimony of personal knowledge.
Right. Well, I will strike the last part. I will take the part that you came to know who you identified the owners of the vehicle.
Correct.
Did you investigate a Morris Broadnax as it relates to this case?
Yes, I did.
Okay. And then, actually, let me reverse that. As it relates to the shooting, were you, did you review the evidence that would have been collected? Let me strike that. Okay, I understand. I need that. Do you see Morris Broadnax here today?
You can stand up.
Yes.
Can you point to Mr. Broadnax and identify a piece of his clothing?
Sitting over there, he's wearing a red t-shirt.
Did the record reflect that the witness has identified the defendant, Morris Broadnax?
Record so reflect.
Did you ever come to learn of an address associated with Mr. Broadnax? Objection. I mean, these questions are leading and they assume facts, not methods.
They are leaving and they do assume facts, not evidence.
What did you do? Did you investigate Morris Broadnax?
Yes, I did.
What did you do in the course of your investigation of Mr. Morris Broadnax?
Objection, that calls for a narrative. These questions have to be open-ended but specific.
I don't know how else to ask if he went to the address or not, or identified an address.
Well, you can take it one step at a time. Basically, what's the first thing you did in your investigation as to Mr. Broadnax? But yeah, it is, you're asking for a narrative. So, you know, I follow the rules of evidence in here. to the letter. I'm gonna hold you to it. I'm gonna hold the defense to it. That's my responsibility.
What was the first thing you did in investigating Morris Broadnax?
I reviewed the police report generated by the shooting.
Okay. Were you able to locate Morris Broadnax?
Yes, I was.
Okay, where were you able to locate Morris Broadnax?
I was able to locate him at an address, I believe it's 12605 Chelsea.
And did you ever learn if that address was related to Morris Broadnax? Objection, that's a leading question and calls for the answer.
Calls for what? I don't understand.
But it asks for the answer in the question. So it's a leading question.
No, because the information is already out there. And then she's asking if that address is related to him, so it's yes or no. It doesn't suggest the answer because the information is already on the record. You know, it's not suggesting evidence. Again, it's not in, there's are facts that are not in evidence. So I'm gonna allow it.
Did you ever come to learn if that address was associated with Morris Broadnax?
Yes, I was.
And you indicated, did you visit that address?
Yes, I did.
Okay. Did you enter the house, or what was located at that address?
The silver Charger with the black front bumper observed in the video and was observed in the front yard.
Okay. What objection was that? I'd like to hear the foundation of that answer, whether it was from personal knowledge or hearsay.
He said he did. The question was, did he visit it? He said yes. And what did you see when you visited? He said he saw this silver Charger that he identified in exhibit number 4 on the grass or on the yard. I forgot how you put it.
His front yard.
Front yard. Front yard. So.
On a jack,
No
missing a
problem.
wheel.
There's, he asked a question. Now you get to cross-examine him on that, but question's proper and the answer is direct.
Can I explain for? I heard him say it was observed, not I observed.
Okay. Did you observe it? I did someone else.
Absolutely.
And what was there any kind of structure located at 12605 Chelsea?
Yes, there was a home.
Okay. Did you enter that home? Just yes or no?
Yes.
Okay. Did you do so? How did you enter that home?
Via search warrant.
Okay. And was Morris Broadnax at that home on the day you entered via search warrant?
Yes, he was.
And what, if anything, did you find at the house?
There was a.
No. What did you find? Someone else found something that's different. Did you find? That's the question.
Did you yourself locate anything at the house?
Yes.
Okay. Did you yourself collect whatever you located at the house?
I called the evidence text to collect and observe the collection.
Okay. What, if anything, did you locate at the house?
There was a Glock 45 caliber pistol with a full auto switch on the back that had a serial number that was registered stolen.
Okay. Did you, what, if anything, did you locate anything else? And briefly, I object to the registered stolen as hearsay.
Their foundation. That issue.
Did you investigate the firearm that was located?
Yes.
Okay. What did you do to investigate that firearm?
I observed the serial number and ran it through the law enforcement information network system.
Okay, and what did you learn as a result?
That it was registered stolen.
That as to hearsay.
Ran it through Lean, that's.
That's correct.
So I'm gonna allow it.
Okay. Did you locate anything else at the house?
Cell phone.
Okay, and, where was the was the cell phone near the gun?
Yes.
Where?
Yes, the gun was in an attic access spot in a closet. The phone was in the same room with the attic access spot on the floor.
And how many stories was this house?
2.
Okay. What floor did you locate the gun and the phone?
2nd floor.
And did you yourself, interact with Morris Broadnax that day?
Yes, I did.
Okay, what, if anything, did you see him do?
Can you repeat the question?
I asked what, if anything, he saw Morris Broadnax do at the search warrant execution?
Oh, okay. What he saw him do?
Yes.
That's the question?
Yes.
When the SWAT team had surrounded the house, I observed Mr. Broadnax yelling from the front door. I
I'm
heard.
gonna stop you there. Do you recall what Mr. Broadnax was yelling?
I don't recall.
Okay, what did you see Mr. Broadnax do, as he was yelling? What, if anything, did you see Mr. Broadnax do as he was yelling?
After he yelled for a small bit, he ran back inside the house.
Okay, and did he ever come back out of the house?
Yes, he exited the home with a backpack that he didn't previously have.
Okay, did, you yourself, observe Mr. Broadnax come out with that backpack?
Yes, I did.
Okay, did you yourself recover that backpack?
Yes, I did.
Okay, and did you yourself search that backpack?
Yes, I did.
What, if anything, did you locate in that backpack?
Power tools and loose ammunition, Blackout 300 was the majority of it. There was several calibers.
Okay. And you indicated that you saw a phone near the gun in the upstairs of that house?
Yes, I did.
Okay, what, if anything, did you do with that phone?
I called it.
Okay, and what number did you call?
I called a number provided by, I believe he was a parole agent of Mr. Broadnax, provided me his phone number.
And do you recall what that phone number was?
I would have to look at my report to refresh my memory.
Would a copy of the investigator's report refresh your recollection?
Yes, but the PIN register warrant probably hasn't for access.
Okay. And I object to the witnesses talking back to prosecutor asked the question, would this help you? You said yes, and added information.
I'm sorry, you're trailing off at the end.
I'm sorry, you're right.
You know, just need to respond to questions asked. Okay.
I have no objection to his answer being stricken from the record, that's fine. Would a copy of a search warrant refresh your recollection?
Yes.
Permission to approach?
Yes.
If you'll take a look at that, read it, let me know if it refreshes your recollection and look up.
Yeah, it's refreshed my memory.
Okay, what was the phone number you called?
313-742-0617.
Take that back from you. And did the phone in the house ring when you called that number?
Yes, it did.
And what, if anything, did you do with the phone then?
I collected it and got a search warrant and submitted it for digital extraction.
Okay. Did you do anything with the phone number associated with the phone?
I requested that it be sent to our phone analyst and mapped out via CPRs.
And were you ever able to verify who that phone number was registered to, if at all?
I do not recall that. I just know that it was.
I'm sorry.
Yeah, just answer the question. You don't know.
What was your answer that you don't know?
Correct.
Okay. Were you ever able to identify who the phone belonged to?
Answer that question.
As an officer in charge of the case, are you familiar with the evidence in the case?
I am.
Okay. And you indicated a firearm was recovered from the house on Chelsea?
Yes.
Okay. What, if anything, did you do with that firearm?
I submitted it with bullets extracted from the victim's car and shell casings to MSP labs for comparison.
Okay. Did you identify any did you yourself respond to the scene of the shooting?
No, I did not. Not on the night. I went there after.
Did you strike that actually? Have you had an opportunity to review the phone extraction from the phone you recovered at the Chelsea house?
Yes.
Did you investigate, were you able to review any text messages from that phone, if any at all?
Yes.
Did you identify the parties in the text messages?
Yes.
Okay. And what did you do to identify parties in the text messages?
I identified a Mr. Boyer, Scott Powell, and Jalen Riggins.
And I'm gonna object at this point for foundation and hearsay and authentication.
The argument?
He's the officer in charge of the case. He's reviewed the phone dump and he's
He
able to.
reviewed it. That's it. He looked at something. He didn't pull it. He didn't do the dump. That means he got information from someone else. Different argument, the judge is to say. I'm gonna strike the last answer given regarding what was got the names of people.
Did you investigate any of the phone numbers in the phone?
Yes, I did.
what do you do when you investigate a phone number?
I take the phone number, I write a search warrant for call detail records, which provides subscriptive information. I also run the phone number in prior police reports. I run the phone number in a system called Clear.
I'm gonna stop you there. What information does Clear give you?
Clear will give me names associated to the phone number via financial information, credit information.
Did you run any phone numbers related to this case other than the 313-742-0617?
Yes, I did.
And if you know, what phone number did you run?
Are you asking me for the number or the?
I'm asking you for the number, if you recall.
No, I would have to look at each call detail record or to refresh my memory.
Well, okay, let me ask this. Did you come to learn of any names associated with any of the phone numbers you ran?
Objection hearsay.
That's not hearsay. Yeah, that's a yes or no. Did he come to know any names?
Yes.
Fair, fair, Your Honor, I think the next, you know,
No, we ain't got there yet.
yeah.
So
What
the answer is
names,
yes.
Yes.
Okay, I want to make sure I heard right.
what names did you come to know?
I think we're here now.
Yeah, we're
Hearsay.
here now. I can pass that.
I'm sorry, I can't answer.
Not yet.
Did you review text messages from the phone?
Yes, I did.
Okay, but you yourself did not dump that phone.
That is correct.
Okay, and did you identify any phone numbers related to those text messages from your review?
Yes, I did.
Okay, and what, if anything, did you do with those phone numbers?
I investigated the phone numbers via search warrant and running them through several databases.
Was there one phone number in particular that you ran through a database other than the phone number 313-742-06?
Yes.
Objection leading. Judge, I feel like I've laid a proper foundation to.
Although I think the question is technically leading, but she did lay a foundation. This witness already testified that there were, well, I got several phone numbers that he was able to see and view based on his looking at this phone. And as a result, he ran those numbers through, he investigated those numbers, running them through Clear and doing whatever else he's going to do with them. Okay, I got that part. Now, I guess, the question you asked, like I said, technically is leading. If you don't mind, I'll rephrase the question. Out of all those numbers you came up with, that you saw personally, was there a number that was of interest in relationship to this case?
Yes.
Okay, thank you. I'm sorry.
Do you recall what that phone number is?
I would need to look at one of my reports to refresh my memory.
Okay. I didn't. Permission to approach.
And I have while you're the witness,
Oh, what?
whether this is a refreshment or a past recorded, it wouldn't recollection. There, so you can refresh a witness's memory if they ever actually remembered it, right? Or there's a past recollection recorded, which is so I don't think that refreshment is the right way to go about for a random phone number.
Well, it's not random, it's part of an investigation that he found his phone number in the phone. So whether or not it's a past recollection recorded or a past recollection that he saw, is the same thing. He still can refresh his memory. So I'm gonna allow it to.
Okay.
Go ahead.
Permission to approach.
Yes, ma'am.
If you'll take a look at this, let me know if it refreshes your recollection as to phone number you investigated as relates to this case. Does it refresh your recollection?
Yes.
Okay, what is the phone number?
313-200-8995.
8995.
Correct.
What if anything did you do with that phone number?
I ran it in Clear, ran it in RMS or previous report system, and I believe that's all I did with that number.
Did you ever learn if there was anybody associated with that phone number?
Yes, I did.
Who was that person?
Objection, hearsay.
Judge, he indicated he ran it in Clear.
It's our business records. I'm gonna allow it.
And can I, while you're the witness, before the court allows it under business records?
All right.
Ms. Wisniewski, Clear is a publicly accessible website, correct?
No,
Is it unique only to law enforcement, or can other people get an account on that?
people can get an account. I believe they have to show proof of having a private detective's license, if I'm not mistaken.
Okay.
But I know you can't just access it without having some sort of prior authorization.
But Clear is not a program run by DPD, correct?
Correct.
Okay. And Clear is not a law enforcement only tool, correct?
Correct.
And you have no idea how Clear receives the information that it does receive, correct?
I've been provided some training which explained that it was, that it goes off of creditor information.
Okay, but you don't have access to those, and DPD doesn't have access to those original creditor reports, or however Clear gets their information.
Not offhand, no.
Okay, and you don't know how it gets from that information into the Clear website, correct?
Not specifically, no.
I stand on my objection for hearsay.
Judge, it's not, it's a document, he's reading from software, it's not a statement.
Well, it's information that is not put forth from, well, I mean, it's personal to who he viewed it. And I don't think it goes to admissibility, it goes to weight. So I'm gonna allow the statement. I'm gonna allow it. Go ahead.
Thank you, Judge. Who was related to the phone number?
Mr. Scott Powell,
Okay.
if you're still talking about 200.
Yes. Yes. Nothing further.
Cross.
Let's talk about the Chelsea address, okay?
Yes, ma'am.
Okay, thank you. So that address at Chelsea is 12605, 12603 Chelsea, correct? Because it's a duplex in a
Correct.
single family home.
Yes.
And
Okay, you did that really fast.
Well,
So
I'll slow down.
12605, and what was the other ad?
12603 Chelsea.
Okay.
And when you entered that home, I guess just to go to the heart of it, would you agree with me that that home was filled with junk and trash,
Yes.
both inside and outside?
Yes.
Okay.
I'm
That
gonna object, Judge, it's assuming facts not in evidence, you never testified that initially. Actually, I'm gonna withdraw my objection. I don't. I'm withdrawing your objection.
that the outside of the house had tons of car parts, trash all around the backyard, in the garage, everything.
Yes.
Okay. And then inside the house had multiple rooms, correct?
Yes.
Okay, and as a duplex, it has a top and a bottom, with a full, a kitchen and a bath area up top and a kitchen and a bath area downstairs.
They were not.
Well, Judge, at this point, I'm gonna object to assuming facts not in evidence. I understand that defense can lead on cross-examination, but just ask the question and you can describe it out.
Doesn't have to do it that way. You can lead on cross. So you can assume facts not in evidence. Assuming facts not in evidence, if you do it, then it's leading. If she does it, it's not, because you can lead.
Okay, Judge.
And inside that Chelsea address, it was equally as trash filled, correct?
I'm sorry, I didn't understand the question.
The inside of that Chelsea address was also filled with trash and junk.
Wouldn't say filled.
Okay, but would you agree that in every room of the house, there was trash and junk inside?
Some, yeah.
Can I approach the witness?
Hold on.
And there, there's some things that's marked.
Does the court care if I mark these as a batch, or do you want them marked individually?
Mark them as a batch. No question them as a batch.
Okay.
Sorry.
No, I saw.
So you physically went into that Chelsea address, correct?
Yes.
Okay. I'm gonna hand you what's been marked as.
Okay. I need to be more specific, because now on direct examination, I got one address. Cross, I'm getting two addresses. So, you're starting to lose me here a little bit.
So you went into the 12605, 12603 Chelsea address, correct?
Yes, I did.
And I'm referring to it as 12605 and 12603 because it's a duplex.
Yes, it is.
Okay. And just for further questions, I'll refer to it as the Chelsea address. Is that okay with you?
That's fine by me.
Okay. So I'm going to hand you what's been marked as Defense Exhibit A.
Okay, before you answer, I need to clarify something, so just I have this picture in my mind.
Council, could you move over so I can see the judge?
Detective, when you said duplex, is this, there's a unit on the bottom and a unit on the top, or they're side by side, or what?
I actually don't know why it's a duplex. It's just registered as one. There's no partition. There's just a stairwell that leads to a second floor that has a kitchenette.
It has one door or two doors?
It has one door.
So there's one door in there and has access to the upstairs?
Yes.
Okay, there's no
partition,
partition separation that, okay, all right, got it. I just want to make sure I understood.
So Detective, I handed you what was marked as defendants exhibit A. Did you have a chance to look through those 3 photos?
Yes.
And do you recognize those 3 photos?
Yes.
Okay. Those photos are a fair and accurate depiction of the house on the day that you went in for the search warrant, correct?
Yes.
And looking at those photos, and so at this point, I move to admit those photos.
Any objection?
No objection, Judge.
Right, admit.
And I'd like to approach so we can talk about those photos together, if that's okay with the court.
What do you mean?
I'd like to look at them with the witness and talk about those photos. I just want to look at them while I cross them.
Well, I prefer you, then you take them, look at them, ask your question, you hand them back.
Okay.
Got them pretty well memorized.
You got them well memorized? Okay, thank you, Detective. Judge, can we just clarify how many photos are in total depicted in Exhibit A? So, just for the record, in Exhibit A, there are 3 photos. Image 9906, image 9901, and image 9902. Those numbers are really only helpful for the parties, as that's how they came to discovery.
Okay.
So, Detective, in these 3 photos, these are photos of some of the rooms in the house, correct?
Correct.
Okay. And for example, in one of the photos with the kitchen, you see trash sort of strewn throughout the floor.
Yes.
And there's old food containers, correct?
Couple, yeah.
And there's, in some of the other photos, for example, living room, there's stuff throughout the room like children's toys, correct?
I think a couple, yeah.
Shoes, random clothing.
Mhm.
There's
Yes.
Yes.
accessories and boxes of things, correct?
Yeah, there's box, yeah.
So random appliances, for example.
Well, counsel, in a minute, you can show me the photos. I don't need nobody to tell me what's in them. I can look and see for myself. And then you can ask what questions you need to ask that are relevant to these charges. Okay? That will get us to where we need to be. Give me 1 second.
And
Give me 1 second. Let me look at them.
okay.
Okay.
And Detective, is it fair to say that the entirety of the house had a similar amount of junk as those photos depict?
I think the downstairs had more junk in the top floor.
Okay. And you have no idea how all that junk got in that house, correct?
Correct.
You don't know who all that.
How is this relevant?
Well, Your
How is
Honor,
it relevant to the charges that your client is facing? That's what I need to know.
I think that the prosecutor is going to argue that.
I don't care what she argues. How is your line of questioning relevant? I don't need to know what you're anticipating her to do. I need to know right now how this line of questioning is relevant to these procedures.
It's relevant to whether Mr. Broadnax possessed the items found in that house.
No. Just because there's junk in the house is not relevant to whether or not he possessed it. Might be all his junk, might be none of his junk. I don't know.
Okay.
You know, I just know at this point that this house is related to him that they went there with a search warrant, he was there. Okay, when they went there to execute the search warrant, he came out. Came out, went back in, came out again, was stopped, detained, and had a backpack search, and certain items were found. That's what I know. I know that the house was, got nothing to it, so what, okay. That don't, this part doesn't relate to his charges.
Okay. At that, Your Honor, then I think I will cede my questioning of this witness. I'm finished with my cross-examination. I would ask that he not be excused until the conclusion of the exam.
All right. Yeah, well, we're gonna be up, right?
No, nothing for the people.
All right, stick around. Yeah, would you please?
How the people will recall Frederick Russ.
Madam Prosecutor. Oh, no. One person. Mr. Russ, come on back up. No, I'm sorry. All right, Mr. Russ, it's gone to oath.
Okay. Okay.
Thank you.
You're welcome.
All right, may proceed.
I'm gonna share my screen. Okay, Mr. Russ, what's up on screen has already been admitted as People's Exhibit 4. Do you view this before?
Yes.
For the record, I'm permission to publish.
Permission granted.
And, for the record, I'm beginning the video at about 20 seconds. Mr. Russ,
Well, you're gonna ask questions, stop the video.
Oh, okay. For the record, I'm stopping the video at 33 seconds. Mr. Russ, do you recognize anything in the video?
My truck.
And can you tell us, can you describe the truck?
White, pearl white Escalade.
Okay, and, are you in that truck in the video?
Yes, I am.
Playing again at 33 seconds. Stopping at 50 seconds. Mr. Russ, can you tell us what just happened in the video?
A car cut in front of me and started shooting at me.
Okay, do you know, have you ever seen that car before?
No.
Okay, do you know who was in that car?
No.
Were you able to see anybody in the car?
No.
Why not?
Because at that time I was ducked out, so I couldn't see no one.
Okay, and, was your vehicle, what was the car doing?
What? Which one?
The
The car was sitting right there shooting at me.
Okay, and, did you hear gunshots?
Yes.
Okay, do you recall how many?
No, I don't.
Were you yourself injured?
No.
Okay, was your car damaged?
Yes.
How was your car damaged?
It was bullet holes. I had like about a total of 12 bullet holes, 12 to 14 bullet holes.
Okay. And what, if anything, did you do after the shooting?
I kept straight. And the car pursued me. Harper.
What if anything happened when the car pursued you up Harper?
It just kept following me, started shooting at me. Never stopped until I think I got to East Point, I think.
And did you call the police?
No, someone else called the police. When the car, because the car actually stopped. So I ran into one backyard and I didn't notify the police.
Okay. And, do you know, if the police took your vehicle?
It was impounded, yes.
Nothing further. Oh, actually, one more question, sorry. Do you know Morris Broadnax?
No.
Nothing further.
Well,
I actually don't have any questions.
thank you.
Okay, the people call Sergeant Melanie O'Rourke.
Your name.
Do you swear or affirm some truth, the whole truth, and nothing but the truth, so much back?
Yes.
Okay, go to door, swear.
Oh,
Sergeant O'Rourke, you have a folder with you.
I do, yes.
What's that?
Oh, it's just my personal stuff. It doesn't have anything to do with the case.
Oh, okay.
I do
All right.
have this though, which is gonna be marked into evidence. It's a copy of my report that I had completed.
Okay, right now I need to
Yep.
place that. face
Exactly,
down.
no problem.
Okay, thank you.
Good morning. Will you please state your name for the record?
Good morning, Melanie O'Rourke.
And are you employed?
I am.
How are you employed?
I'm a sergeant with the Detroit Police Department, Major Crimes.
Okay, and what are your duties in that role?
I do forensic analysis of cellular call detail records and tower mapping.
And is there any, how long have you been employed in that role?
Over 7 years now.
And is there any particular training required to do the job that you do?
Yes.
Okay, what is that training?
Just to name a few, I've had T-Mobile training. T-Mobile is the prevalent company here in the Metro Detroit area. I've had Excel training. Excel is a format that most of the call detail records will be returned to us in. I've had cell phone use and drug trafficking training. I've had PenLink training. PenLink is the program that the Detroit Police Department uses. Basically, it puts all the records that we receive in a readable format. I've also had CATS training, which is an acronym for Call Analysis Training School. I've had PLX training.
Okay, I need to stop.
The witness is an expert also.
I'm sorry, I can't.
I'm sorry. I'll stop doing that, but this is, the witness, I stipulate to the expertise of the witness.
Okay.
That's the cell phone analysis, that's what we're talking about?
Cell phone mapping.
Forensic analysis of call detail records and mapping. Okay. Sergeant O'Rourke, did you, what are call detail records?
Call detail records are simply historical data from the cell phone company that we received.
Okay, and did you analyze any call detail records as it relates to this case?
I did.
Okay, and what, if anything, did you do when you analyzed those records?
Basically, we receive call detail records, which is historical data from a cell phone company. We will input that information, which is the raw data, into our system called PLX or PenLink, and then that'll put it in a readable format, which we will, I believe you have it here report.
Okay, did you author a report in this case?
I did.
Okay. And let me just take it back. Did you analyze raw detail records in this case?
I did.
Okay, how did you get those?
I received them from the officer in charge, the OIC.
Okay, and Did you analyze the records for a certain time or date?
I did.
And did you make the decision, as to what time or date to analyze?
The officer in charge will give me a specific incident with a date, time, and location. And at that point, that's what's going to be mapped in or around that area.
And was there a particular phone number associated with the record to analyze?
Yes, but I did not memorize that.
Would a copy of your report refresh your recollection?
Yes, please.
Do you have a copy of it up there?
I do.
Okay, permission, judge, for the witness to look at the report.
Yes.
And what was the phone number you analyzed?
The phone number is 313-742-0617.
Okay. And did you know that phone number to be associated defendant?
Yes.
Okay, who was associated?
Hearsay as to that.
Objection sustained.
Did you investigate that phone number?
I did.
Okay, what did you do to investigate it?
So that information is received from the cell phone company and historical data, and then we upload it into the system and for a specific date, time, and location.
Okay, did the information, did you receive raw records from
I
the
did.
cell phone company? Okay, and did those raw records reflect that anyone was associated with that phone number?
There was a name on the subscriber information. I did not receive that information. That was given to the OIC, the officer in charge. I'm sorry.
Okay. Okay, you indicated you'd authored a report in this case.
Yes.
Actually, at this time, the people are now going to move for admission of people's proposed exhibit 11 is people's exhibit 11, the raw call detail records, and the certification from T-Mobile for phone number 313-742-0617 under MRE 8036 as a business record.
No objection to this document.
And I'm also
Okay,
moving.
I just want to make sure what you asked to admit the raw records,
Yes.
or you're asking to admit her report?
No, I'm not admitting the report right now. I'm admitting the raw records with the certification under MRE 8036, not through the witness.
Give me offer of proof. How would the raw records be relevant to this court, or this hearing?
The witness analyzed those raw records in order to produce a report, so they're the underlying information for the report.
I understand that. But we got that on the record, so why do I need to see them?
Okay, that's fine. I guess I don't have to admit
If you
that.
admit it, just hold on, counsel. If you admit it, I gotta look at it,
Okay,
okay? So, but we already got that information on the record, that she used certain raw records to do her report. And I assume the report is gonna be what's relevant,
yeah.
okay?
Okay, so I guess at this point, I'll just only move to admit, since we've heard testimony, the certification from T-Mobile as it relates to the phone number, the 313-742-0617.
Any objection?
Not as to the certification, no.
All right, wait a minute.
Then would you like a copy of it?
Yeah, I got it, yeah.
Well, Sergeant, do you have a copy of your report in your hand?
I do.
And is that the report that you authored as it relates to this case?
Yes, it is.
Okay, has it been altered in any way?
I don't believe so.
Okay, and how many pages is it?
3.
Okay, permission to publish, move to admit People's Proposed Exhibit 12 is People's Exhibit 12, the report that Sergeant Mellier were authored as it relates to the mapping of 313-742-0617.
Any objection?
Can no,
Wait, let me make sure. I thought I heard you say 743. Is it 743 or 742?
742, sorry.
742 0617, right?
That's good.
Okay. You have any objection to admitting the report? Admit.
Judge, may I approach with a copy or may I publish on screen? I'm not sure how you want to view it.
I'll look at a copy, and you have a copy, right? Of your report. I don't need it, you might need it.
Yeah.
Ask the question. You have another copy?
I think so.
Okay.
We're looking at page 1 of People's Exhibit 12. Can you tell us what the top black bar depicts?
So there's a couple of different headers. The first one is just simply the row, so we can know which row or which information that we're talking about. The second is going to be the target, which is the actual phone number we received with the call detail records. The third is the target name associated with that target number.
I'm going to stop you there. Where do you get the target name from?
That's provided by the OIC, the officer in charge.
Okay. And what's the next row?
We have the date,
Okay.
time, the duration is how long any of the activity was, whether it's a text message, a voice call, things like that. So we have the duration there. Then we have the start black said, which is the tower information, location information that we map. Then we have the call type. Again, I was just explaining voice, text message, if it went to voicemail, things like that. Then you have the call status, whether it was completed, incomplete, the unknowns are generally under voicemail. You have the direction, whether it was incoming or outgoing, the activity itself. And then you have a contact ID. So the contact ID is what the target number was interacting with. If it was a text back and forth, it was a call back and forth, that's the contact ID.
Where do you get the contact ID information from?
That's provided by the cell phone company.
Okay. And what date does this mapping depict?
So this mapping depicts from February 6th of 2023 from 2308, the call records are received in military time. So that's going to be at 11:08 p.m. through 11:54 p.m. or 23:54.
There are colors on each row, is that fair to say?
Yes.
Okay, what does each color mean?
So each color, depending on what line that you're looking at, for example, line 1, row 1 is going to be in purple. That actually is going to coincide with the tower information and location on page number 2. So you have, and we haven't discussed page number 2, but on the actual map, you'll see a color of a tower along with some lines, and that's going to coincide with the exact date and time and duration for that information on that specific row.
Okay, and what is the red row?
So the red is indicative of just the scene information that was provided. At this point, it says Harper and Dickerson. That's the only information I received, a date, a time, and all that information is provided by the officer in charge.
And what is the time?
The date is February 6th of 2023 at 23:42, which is 11:42 p.m.
Okay. And is that red bar depicted anywhere on page 2 of the exhibit?
So that red bar, as you can see, coincides with the red, almost little dot on page 2 that you see on the sort of the middle right-hand side. And that is going to be the location of the quote-unquote scene.
Okay, and are all of the, and what is each, I'm sorry if you said this already, but what is each of those bars on pages 2 and 3, what are those?
So on pages 2 and 3, you see, which almost looks like a V. Those are indicative of the coverage area, the intended coverage area from a cell phone company, the sectors that they're stating that covers the area of the tower.
And how far out does, if you know, what a T-Mobile tower cover?
So T-Mobile generally will be anywhere around a mile. It's usually around 0.82 of a mile, but here in this instance, in order to have uniformity, is all going to represent the lines. It's going to be a mile.
And would you know how close a phone would have to be to a particular tower to hit that tower?
I don't understand your question.
Okay. As it relates to, let's say, the green tower that's depicted in rows 5 through 9, would you know how close a phone would have to be in order to be in the area of the green bars?
No, so these are just general intended coverages and sectors provided by the cell phone company. So we don't know an exact location of a device where it's going to be. This is just the intended coverage and within that intended coverage.
Okay. I'm going to draw your attention to line number 3. Can you read the contact ID?
Yes, the contact ID is 313-200-8995.
Okay, and at what time is that activity on line 3?
On February 6th of 2023 at 23:48, which is 11:48 p.m.
Okay, and for line 4, can you read the date and the time of the activity?
February 6th of 2023 at 23:49, which is 11:49 p.m.
Okay, and what is the contact ID there?
That's going to be 313-200-8995.
Now looking at page 3 of the exhibit, is it fair to say that the phone was active in the areas depicted in the, let's say for row 5 through 9 in the area of the green bar?
Yes, that is the intended coverage, yes.
And as it relates to the black bar in row 10, at what time is the phone active in the area of the black bars in row 10?
On February 6th of 2023 at 23:54, which is 11:54 p.m. There is a location information for a completed outgoing voice, and in the coverage area, in the intended coverage area for the black, which is out just west of the scene.
Is it your opinion as an expert that the phone number is active in the area of Harper and Dickerson at around 11:42 p.m. on February 6th of 2023?
No, so we don't have any activity during that 11:42 p.m.
When is the next activity after 11:42 p.m.?
At 11:48 p.m.
And when is the next activity that's detected before 11:42 p.m.?
At 11:08 p.m., 23:08 p.m.
And where in row 3, where is the activity occurring on this map in page 3?
That's going to be in the light blue area. If you see, it's going to be the tower it's the foremost east on your map. It looks like a straight line going straight up. The light blue.
Is it possible for somebody to be in the area of Harper and Dickerson and to be pinging the green area depicted in rows 5 through 9?
Yes, it could be.
Why is that?
So when you're dealing with any type of cell phone, you're dealing with radio waves, and it's not going to be exactly a mile. It's not, I mean, it ebbs and flows. It can be a little farther, it can be a little shorter. That's why we use the mile here in the Metro Detroit area, because that's the usually the average of how far a device is going to be away from any type of tower that it connects to.
No, nothing further. Fair to say, officer, you don't have any idea who had physical possession of this phone on the daytime?
No.
And these towers that you've identified, they generally run along I-94?
Yes, it looks like it.
Okay, and I-94 is a major interstate highway?
It is.
Okay, and so these towers are likely to pick up the signal of anyone any active phone on the highway there, correct?
Yes.
Okay. I don't have any more questions for this witness.
Nothing from the people.
Thank you. The people called police officer Christopher James, the last witness. You're on.
Judge, fortunately, at this point, I'm gonna have to ask for an adjournment for the one final witness to testify at a different date. If it's possible, this court will allow a held in part.
I don't do holds apart. Why would I do that? Why isn't your witness here?
He's here.
Oh, why can't you come testify?
There's one particular piece of evidence he needs to review before he can, and I don't want to put him up before I can assure I shared the reports and the evidence for the witness to review. He hasn't had a chance to review that.
This is. Give me an offer of proof.
It's the witness will testify to the phone dump, the phone extraction. There are several exhibits people intend to admit. However, the officer needs an opportunity to review the actual phone extraction to ensure that these exhibits actually came from that particular phone extraction, because there were several phones that were extracted in this case. And I don't want to put the officer up if he can't say that for certain without an opportunity to review the phone extraction itself. My understanding that officers at Detroit Police Department Cybercrime pull the phone up, put it on a disc, but they don't review it unless they're asked to review it. And so I'm asking the court for an opportunity to be able to authenticate the exhibits once the officer has an opportunity to review said phone dump.
Okay, so I guess my question, how is that gonna strengthen your case?
If I may, the people are seeking to admit photos of the vehicle that was depicted in the video from the defendant's
That's a
phone.
vehicle in the from what?
From the defendant's phone. It's a very distinct vehicle. The defendant has at least 3 pictures in his cell phone of the distinct vehicle depicted in People's Exhibit for the video. And then additionally, there are text messages about shooting at a white vehicle. That's what the people are seeking. That's the offer of proof that the people are seeking to admit. The text messages were sent on February 6th to Scott Powell on the same day earlier that day about,
The text messages are coming from what phone?
from the defendant for Morris Broadnack's phone from the same phone number. The text messages on page 3 said, I'm on your ass, Ben.
No, you can't say what they say.
I didn't know where you wanted me to go with the offer.
I mean, I object. At the beginning of this exam, the prosecution affirmatively stated we're ready to proceed with this exam. This has been a long drawn out process. We are set here today on May 18th for a preliminary exam. We had our first PCC on April 28th. Not only that, but this discovery was available to the state and in receipt of the state since March, I think. I don't see any good cause here to continue this so that the people's witness can review discovery that has been in their possession for 2 months. Mr. Broadnax is, he's posted a large bond. It has been a long drawn out process for him. And these text messages aren't to the complainant. They're not to Mr. Ross. So I object. I don't think that the people have shown good cause for an adjournment, considering that this is their discovery that they've had access to for well over a month or 6 weeks.
Yes, on that, rebuttal.
Okay.
I'm talking to the prosecutor, she gets rebuttal, her motion.
The people are asking this court to find good cause for the adjournment. The people have given an offer of proof. At this point, people don't feel comfortable moving for bind over without this particular piece of evidence. I can assure the court that the people have shared the evidence with the witness ahead of time. And people understand we have the discovery from the beginning of the case.
Well, why can you share with them now? And let them review it, and then he can testify. What does he have to do?
He has to look at the phone dump. The issue is the phone dump is very large and it takes a long time to open. That's the concern. Otherwise, I would show it to him now.
So how much time do you need? I've been really generous with my time on this, and it's put me way past required time limits I'm supposed to have these done by.
If I can have, the court will allow me to do it now. It just will be contingent upon how long it takes for the phone dump to open. I can do it in the same day. Or unless the court wants to bring us back one day next week or tomorrow, whatever works for the court. As far as I'm concerned, I understand defense counsel makes a special to work with as well.
Hey, can I share something with the board? This, and I think I said this before, but we were here on an exam on March 24th for a prior case, and we talked about how we got all these giant phone dumps. That's that phone from March 24th. So they've had this.
Well, you don't get to argue it again.
Okay.
I argued the first time. No, that's not sharing. That's arguing some more.
Okay, you're right. I'll sit here.
All right. I'm gonna grant the motion and give a short adjournment. Don't be short. Do this Tuesday, May 23rd at 11:15.
Works for the people.
I couldn't hear you, I'm sorry.
It works for the people.
Does that work for you?
It's gonna be really tight for me. Can we do 11:30?
All right, no.
Thank you, Judge. I appreciate the court's indulgence.
Oh, Madam, I need, the adjournment is yours, so you gotta give me a form, please.
Yeah, say one more time.
You gotta give me a form, the adjournment's on the people.
Oh, in order?
Yeah, no, yeah. The order, please.
Tuesday, the 23rd at 11:30.
I don't get it. Permission to approach.
Yes, ma'am.
Yeah, I go.
Look, I'm spilling over water. Eleven.
Hey, kid, let me get that.